Hello everyone, and we're here again with another short video lecture. I'm going to do this one on the Butchers Benevolent Association of New Orleans versus Crescent City Livestock Landing and Slaughterhouse Company. Louisiana is unfortunately a state that is fraught with many issues and are as current as Katrina all the way back to 1870s when they got tangled up in this issue. And basically what ended up happening was that Louisiana gave a 25-year monopoly to this Crescent City on the grounds that it was for the betterment of the people's health in the city of New Orleans. And so this other group was actually an association of slaughterhouses in New Orleans who felt that this was unfair, and it just on its face seems like it was unfair. And they tried to argue that it violated the 14th Amendment, which is the Equal Protection Clause in this case. Like I said, it was around 1873. It was decided in April of 1873. It's interesting because as far as time, it is in the same basic time frame as Plessy versus Ferguson, which is another interesting case of a man who was partially black who tried to ride on a bus, which back then in the 1870s, a bus consisted of a very large carriage, like a bus we would have today, with like 12 horses on the front of it. So he tried to get on there and sit in the front, and they wouldn't let him, kind of like Rosa Parks did, basically nearly 100 years later. And so basically what we're looking at here is, a basic situation of, is the 14th Amendment just for black folks or minorities, or does it actually apply to all people in this country? And it's very interesting because the plain reading of the 14th Amendment says that it applies to all citizens of the United States. It seems very clear. But yet the court in that particular case indicated that because the 14th Amendment came right after the 13th Amendment, which abolished slavery, except for the case of criminal justice, where a person is found to be a criminal, then the 13th Amendment does have an exception built into it that criminals can be subjected to conditions of slavery. So what they're trying to say is the 13th, 14th, and 15th Amendments are all kind of in the same time frame, and so therefore it was only intended to be for actually black slaves. But the honest truth is that it's not written that way. It's written in broader terms, and it's been interpreted ever since about 1954 in its broadest context. And yet in these early years after it was passed, it was considered to be just for former slaves who happened to be black. So that was one of the, basic contention points here, and so as we look at this in the lower courts, they found in favor of Crescent City. They threw aside all the Butchers Benevolent arguments on the 14th Amendment. They didn't see how that had anything to do with due process, privileges or immunities, or equal protection at all. And so they said it only applies to federal government, not the state. Well, that's clearly been thrown aside in cases like Miranda, MAP, and we can just go on and on. I mean, all the cases decided on certain rights, criminal rights, First Amendment rights, a number of other things. Every one of them almost involves the 14th Amendment, which applies the law to states. In other words, it applies federal law to the states. Whereas even at this time, even after the Civil War, people were still hard-fast arguing that the 10th Amendment allows states to kind of run their own show and the federal government should not interfere. The problem with that basic argument is it's just not logical when you take the big issue of the time, which was that states were no longer allowed to sell people as slaves. So therefore, you know, it obviously doesn't work, because if it's on that big issue, then the federal government can regulate almost any issue if they can see an inkling of where someone's rights are being violated. Basically, the argument is the plaintiff says that the state should not have the power to give exclusive contracts to companies like Butcher Company, and so they shouldn't be allowed to create monopolies, is what the argument is, and that by doing so, it is a violation of the 14th Amendment, because it does affect their equal protection and due process rights. I mean, they're saying ipso facto that all these other butchers are unsafe or unclean or something like that by saying this is going to be the only butcher. Plaintiff wanted a writ of injunction to stop this law from going into effect, which would have allowed Crescent City to dominate all of the meat packing in the city of New Orleans. The majority vote was 5-4, and any time that you see court cases with a 5-4 majority, that's a shaky case, and it's going to be revisited sometime in the future. So basically, as you can see where this is headed, by a 5-4 decision, Samuel Miller wrote that the Crescent City Company was legal, that they were allowed to have a monopoly on meat for safety purposes. And if we go back to last semester and we look at some of these decisions, like Philadelphia pilot situation, remember that case where the city of Philadelphia could choose a pilot to pilot a foreign ship into their harbor. I mean, that had a good safety basis. It made sense. But in this one, it doesn't really make sense. The better way to go would be to regulate all of the butchers and make them all meet standards, which is what we do modernly now, is try to make sure that the food is safe, the place is clean, and you know they use the best practices in preparing the food. So this would be a more fair approach, and that's the approach we use today. So here again, even though they did make this decision, it was a short-lived decision, and it just demonstrates, just like Plessy and a number of other cases, that there can be bad decisions that are revisited later and are changed. Just for your information, the majority voters in this were Samuel Miller, Nathan Clifford, David Davis, William Strong, and Ward Hunt. And this was a time period, it's a very odd time period, from like 1870 to about 1920 in the makeup of the court and the decision making of the court. It's almost like a laissez-faire type of Supreme Court, so it wasn't really that favorable in terms of the rights of the individual. In a strong dissent, Stephen Field, along with Noah Swain, Stephen Field, Joseph Bradley, and Solomon P. Chase, the same Solomon P. Chase that served on Lincoln's cabinet, basically argued that a citizen of a state is now only a citizen of the United States residing in that state. And so basically what they're trying to say is you have dual citizenship. And that is funny, but in the future, the dissenting opinion will become the majority opinion. So basically, why we're even talking about this case, this is not good law. If you shepherdized it, it would come back as being not good. But the point of it is that, you know, it's kind of the history of this issue. And so it's going to change in the future, but just want to alert you to it. And so, you know, I think a good thing would be to brief the case. So if you go to Shepherdize 83 U.S. 36 and see what it says. And, you know, my thinking to this would be that there should be a number of cases that show that it's overturned. So what I want you to do for your brief or forum post is present me with one of the cases that says that Butchers Benevolent Association is no longer good law. So take a shot at that. I'll work on it too. I'll have some future posts in this area, and so I will share that with you later. So hope you enjoyed it. Take a look at this, see how the law evolves over time. That's the purpose of this. This is a bad case, but at the time it was the law in the 1870s. So take a look at it and follow up and see just what's going on. So we'll move on from there, and we'll come back with some more video here in a little bit. Thanks a lot.